But a second question, if we were to get more into the weeds here, take it a step further, should the judge approve an ESI protocol? Some parties want the judge to sign off on this, make it a court order. That certainly triggers more rules in the Federal Rules of Civil Procedure. But Judge Goddard, why don't we stick with you for this one in a second? Do you think you need to sign off on these ESI protocols?
I'm happy to do it. If you don't submit it to me, I won't necessarily even know you have one. And if I've had some involvement in pushing you, I probably want to do it. And the reason for that is I go back to rule one, just, speedy, inexpensive. I think it streamlines the process if there's problems down the road, if it's already in order. That's the only reason why I would do it. Any order I would sign would certainly give me the leeway to change it and some flexibility down the road. But I do think that I know that there's some judges who are like, that's not my deal. I'm not going to do that. And they just won't, even if it's presented. And that's certainly their prerogative. But I find that if there's problems, it's kind of solves one, it takes care of one step along the way. If it's already a court order and sanctions become an issue that the court needs to look at.
Thanks, Judge. Judge Richland, your take on this. Do you need to sign off on these things?
Yeah, I don't have a problem signing one, but what I would say is for litigants, I'm not really sure what the concern is. I don't think you need a judge to sign it. I think a stipulation of between the parties on a discovery issue is enforceable. So even if you didn't ask me to sign it, in advance, if the parties have agreed to something and there's a violation of that agreement, I'm happy to review and enforce an agreement. So I don't think it's necessary.
Thanks, Judge. And Judge Barksdale, your take on it.
I would echo Judge Richland. Just like a confidentiality agreement, we will enforce an ESI protocol if the parties have agreed to it and it's reasonable. And so no need for an order here in the Middle District of Florida. And we rarely see parties asking for one. In fact, I can't think of one in the past several years where a party's asked for a court order on ESI protocol.
Thanks, Judge. Let's kick off this next question with Judge Richland. And this is one that has been debated a little bit as well. And that is, should every matter have an ESI protocol? And if not, which types of matters should have an ESI protocol? Judge Richland, as our audience knows, Federal Rule of Civil Procedure 26F calls for a discovery plan, but there's nowhere in the federal rules where an ESI protocol is required. So let me toss this one to you and ask you, do you think there needs to be an ESI protocol in every case?
No, I really don't. I like Judge Goddard's approach, where I know she really pushes the parties just to think about it. I think that's the right answer. The right answer is you have to have a discovery plan. Discovery plan means talking about what kinds of documents and information are out there. Is ESI a big issue in this case? I've seen every, all sides of the spectrum, and I've definitely seen those cases, maybe smaller cases, where one side wants all the ESI in the world and there's nothing there. I mean, I find myself asking, why do you want every text message ever created? I mean, if it's relevant and it's going to make sense, great. But do you really want all of that data dumped on you, or what are you going to do with it? So I just encourage the parties to think about it. Let's talk about it. And let's also talk about what kind of ESI, is it Teams messages? Is it meetings that might be recorded, like Zoom meetings? Is it text messages? There's so much there. So I think part of the discovery plan process is really just being thoughtful about it. Is ESI a big issue in this case? And then also, how much of an ESI protocol do we need? We may, depending on where you are in the litigation, you may only need to start thinking about preservation and collection. You may not need to address every aspect of that all at once.
Thanks, Judge. Let's go on to Judge Goddard on this one. And Judge Goddard, you have your checklist for Rule 26 conference, and that's part of the materials that our attendees can take a look at. And in the past, you've noted that ESI protocols can create efficiencies in complicated cases, But same question to you. Do you need one in every case?
So, and the answer is no, definitely not. And especially a lot of the people who are attending this webinar are dealing with the cases where you probably should be thinking about in every case. But we deal with a lot of cases, and I try and remind people this, where these issues never come up. Like in California, we have lemon law cases that involve like issues with cars and products liability. We have personal injury cases sometimes that make their way into our courts. But if you're looking at having your client pay for a discovery vendor, you really should be thinking about whether or not there should be an ESI protocol to make sure their money is well spent and make sure that you're not going to run into problems down the road. I have my Rule 26 conference checklist. Thank you, David, and several other e-discovery professionals, some of whom were in the webinar, who helped me with that, who took a look at it and made sure it was comprehensive. And that's designed basically to be like a roadmap for, do we need one? If you're hitting kind of complicated issues, or you're finding that it's difficult to agree, or people have different perspectives, then that's a sign that you should probably be thinking about having an ESI protocol. But I think it's a good rule of thumb. If you're going to pay a discovery vendor, you need to be thinking about whether that's appropriate. And that doesn't mean necessarily that it is, but when you're putting that much of an investment financially into discovery, you really need to think about whether it's appropriate. If I can circle real quick, David, Kelly Twigger had a good question going back to having a judge sign the ESI protocol. Her question was, can you argue that a violation of the protocol is sanctionable under Rule 37B2 if it isn't signed as a court order? And that ties into what I was saying under Rule 1. I do find that it adds a level of efficiency. It's kind of a belt and suspenders. If you find yourself looking at sanctions issues down the road with respect to the ESI protocol, if it's already been signed as an order, it's a little bit of a shortcut. I don't know that it's necessarily critical when you're in that kind of a mess of looking at sanctions, but I think that's a good question, and that's one of the reasons why I'm not hesitant to sign them.
Thanks, Judge, and thanks, Kelly, for the question. Moving on to you, Judge Barksdale. We've talked about Judge Goddard's checklist for Rule 26. In the Middle District of Florida, you have Middle District Discovery, and that gives somewhat of a roadmap as well. What's your take on this? Do we need them in every case? How does Middle District Discovery act as a guide? And if we don't need them in every case, which types of cases?
I agree. You don't need them in every case. You know, just like every human, every case is so unique, and just have to confront the case as a unique case and figure out whether having an ESI protocol will lend itself to speedy, inexpensive, and just. And that's the question I think each lawyer needs to ask themselves. Will an ESI protocol lead to speedy, just, and inexpensive? And if it won't, don't have one. If it will, have one. But I'm really glad, David, that you mentioned our discovery handbook because it's really helpful whether you're practicing in the Middle District of Florida or elsewhere. It has a really nice sort of layout on e-discovery, including sections on preservation, proportionality, and what should be discussed at an ESI conference. In procedure, metadata, it has it all. It's a great outline to use. And so whether or not there's an ESI protocol, you certainly should go down this sort of procedure checklist to think about these issues in every case.
Thanks, Judge. Appreciate it.
Can I add, David, real quickly? Just
Sure, please.
I know because I hear from people who say that it can be a real nightmare to negotiate ESI protocols. And that alone can make you say, do I really need it in this case? But I guess I would just say, like, if you're dealing with an MDL, if you're dealing with antitrust or a really heavy discovery, I get that it's really a lot of work to negotiate an ESI protocol, but you really have to ask yourself, isn't it better to do that up front than instead of negotiating up front, litigating? I know what's better for the judge. It's better for us if you hammer it out up front. So just keep that in mind. I want you all to know we hear you, we see you. We know it's hard, and we appreciate the work you put in when you put it in up front to avoid the conflicts down the road.
Thanks, Judge. Let's keep going with that same theme, because I know a lot of people say, all right, don't just kick the can down the road, deal with the problem when it arises. But if you were attending an earlier session in this series, Craig Ball, professor out at the University of Texas Law, had an interesting analogy, and his was, don't eat the elephant in one bite. Having never dined on elephant, I'm not sure how you'd go about that in the first place. But what Craig is saying is when it comes to ESI protocols, he means seek agreement on the core issues. And we'll get to some of these, such as form and method of production. And he's saying reserve the contentious ones for later on down the line. And he mentioned tar validation as one of those contentious ones. Judge Barksdale, why don't we start with you on this one? How big a bite should parties take out of the ESI protocol elephant? Should they try to include as much as possible, avoid kicking that can down the road later? And, you know, one of the seminal cases in ESI protocols, Henry Baltersan, we saw a court hold that a litigant violated and a court ordered, and in this case, it was a court-ordered ESI protocol by the unilateral use of tar without collaborating on its use, as the ESI protocol called. What do you think? Biting off a little less of the elephant here? Do you think save the contentious ones for later or try to resolve it at the beginning?
Yes, I say save the contentious ones. I mean, cases just change throughout the litigation. They don't remain the same, especially as discovery is being collected. And so I think lawyers do a disservice to try to cover everything up front without knowing, you know, all the information they need to know to cover everything. I feel bad for lawyers in a way. They're governed by so many rules already. The federal rules of civil procedure, the court's local rules, standing orders in some cases, and then through a protocol, they're adding a fourth thing to be governed by. It's just a lot. And so trying to resolve, you know, very general, easy issues up front is wonderful, but trying to resolve everything is very difficult and just adds yet another rule to follow and yet another rule to break.
Thank you, Judge. Judge Goddard, let's get back to you on this one, on how much of the elephant from the very beginning. And, you know, when we've discussed this in the past, you've mentioned flexibility might be a good thing, and perhaps things on the ground can change. How do you think about addressing them?
Well, Walterson's an interesting case because I feel like the parties did that. What they did was they had an initial agreement, and then they said they'll cooperate in good faith regarding the search methodology. And then that's where it broke down. So I definitely think you shouldn't try and swallow the elephant in one bite. But I think you should remember when you've promised to confer with the other side that you need to actually do that when you get to that later step in the case. Because I think that's kind of where things went off the rails there. But I think for sure, when you're starting the discussion, that the first thing you should do is you should confirm the scope of the legal hold that's been placed and get a good sense that you are in agreement with the universe of documents or information to be searched. And then also look at an opportunity to exclude sources of information. Maybe both sides use Slack, but it's not going to be what decides the case. Maybe you can agree that neither side has to pull the Slack data, or you can limit it to a great extent. Those are the types of things you should decide up front, but don't forget, if you push the harder stuff down the road, that you did agree to talk to them about the harder stuff too. So that's the lesson of Alderson, I think. But I think it's logical. And I don't think that judges if I see from the outset, like a fully fleshed ESI protocol where everything's all set, my assumption is that they've pulled it from some other case that they've changed the names on the pleading, in the pleading, and that they haven't really thought it through. So I'd be more suspicious of something if they tell me they have all the answers up front.
Thank you, Judge. Judge Richland, let's get your take on this. And Judge Goddard has thrown in the possibility of a boilerplate ESI protocol rearing its head in this one. What do you think? Try to resolve the tough ones at the beginning or save them for later and get what you can get?
Yeah, I think start where it makes sense. For example, during the discovery plan in the beginning, I mean, you're really focused on preservation and probably production specifications, but you may not, it just may not make sense to have a fully fledged agreement. And I've definitely seen what Judge Goddard talked about, where parties have clearly taken a really detailed ESI protocol from one case and used it in another case without being really thoughtful about it. And I think they kind of regretted it later, where there were a ton of disputes and they had agreed to all of this complex procedure that just made no sense for this case. It definitely felt to me like one side had taken a complex protocol from a big case and tried to apply it to a small case where it was too much. And just resulted in a lot of disputes. So I think that was just a good lesson in go slow, focus on what you need to in the beginning, keep talking, and keep agreeing and keep talking, but just go in phases.
Thank you, Judge. Appreciate it. And for those of you who will be seeking CLE credit, our CLE code word, keeping with this theme, is elephant. Once again, the CLE code word is elephant, ELEPHANT, and it was given to you at 1:31 Eastern Daylight Time, if your state bars require that. All right.
Hey, David, can I interrupt for a second?
Please do.
So one of the participants asks a question, and I would love Judge Goddard's take on this. And it is, some attorneys are arguing against ESI protocols. One Law 360 article claimed ESI protocols are going the way of the dodo. They say now that e-discovery is mature, detailed protocols restating well-established obligations are no longer required and can be disruptive. Do you agree? So I'm not sure if I agree with that, but I wanted Judge Goddard's take if she's willing to give it to us.
Oh, sure. Definitely no, but let me get to it. And I also answered another question. They were looking for the link to your discovery handbook, Judge Barksdale, and I included that in there so they could see it. And so hopefully everyone can see that. I didn't mark it private. But I think that I'm not familiar with that Law 360 article, but I think one of the things that has changed is it used to be when e-discovery kind of came out, everyone was like, oh my gosh, if you've got to have an ESI protocol. But I think people are, and I remember in our district, we had a boilerplate ESI protocol, and we've taken it out of our local rules because what we've learned is that if you need an ESI protocol, there really is no such thing as a boilerplate because it has to be tailored to the case. So I would say that article's right in the sense of like a boilerplate ESI protocol that you could apply in any case. That notion is gone, right? But I do think, and the reason what drives, I think, the need to have this kind of upfront agreement is the expense involved when you have a very complex case and you're spending a lot of money on discovery and you want to make sure you're doing it the right way. Like if we go back to that I don't know if it's Valsartan or Valtarsen, I don't know. The Vol case, that case where people didn't do what they were supposed to. If you go back to that case, that's a side that's paid a ton of money to the defendants in that case, paid a lot of money for a review protocol that ended up costing even more money down the road because they didn't go back and get some buy-in or bring it to the court when they couldn't get buy-in at the outset. And so I think that you have to be really careful. Why are you really doing this? Are you doing the ESI protocol for the court? Are you doing the ESI protocol so that your client is litigating efficiently? And I think there are still a lot of cases where that's necessary, but in the run of them, probably not.
Thank you, Judge. Judge Richland, I want to give you a chance on this one if you want to dive in. And we've also got another very good question. Judge Richland, let me see if you have any response to this one before getting on to our next question that we've got.
Yeah, I think, maybe the issue is just, maybe we're not calling it an ESI protocol anymore, but, I think you definitely need to be talking to the other party about some of the key issues that would be in the ESI protocol. So whether you want to have it be formal or whether you want to call it that, the meeting and conferring needs to happen because, when you're producing ESI, you need to be talking to the other side about what kind of ESI do you have? What kind of systems? What files, what metadata do you have? And, for things as simple as production specifications, the last thing either side wants to do is to invest a lot of time, resources, and money in a large electronic production and then have the other side say, wait, I can't use that. I'm not using relativity, or you didn't give me any of the metadata fields I wanted, or, it's a waste of time and money for all sides. So I think that basic discussion between the parties about data, about metadata, about production specifications. I think that is all key to any ESI protocol, and whether you want to have it be that formal or call it that doesn't really matter. But I think that has not gone the way of the dodo.
Thanks, Judge. The next question that we've got from Maria is, say a party refuses to discuss ESI issues and they're required by 26F, and these are issues that are commonly addressed in an ESI protocol. How would the judge handle this one? And, you know, Kelly Twigger mentioned, well, gee, if you have that court order, you can get sanctions under 37B, which are easier to get than they are under 37E. And Maria's asking, would you even consider going for Rule 37E sanctions for noncompliance in this case? Anyone want to jump in on this one?
So I can just tell you that in my court, the way you'd have to do this before you could even get to motion practice would be you'd have to send me a joint email letting me know that there's a dispute, or that they're just not willing to talk about it. And then you'd have a Zoom conference with me where I would say, all right, talk about it.
And I would do,
if they refuse to engage, it'd be a problem.
and I would do the exact same thing. This is the perfect issue for an informal discovery conference. I'd want to, you know, you don't need to jump right to sanctions. I think this is where you jump to accessing the court and that helpful supervision of, because then I'm just going to ask, why are you refusing to talk about this? What's going on here? And then I would think that we would work it out in an informal video conference.
And 37F, which is what Maria had mentioned in her question, is something we don't see a lot. We used to talk about 37E sanctions, but 37F is for failure to participate in framing a discovery plan. And I think you'd have to make a record of that failure to participate. So if they weren't doing it, even though they should, at the invitation of the other party, then the court would extend a gracious invitation. And then if they decided not to participate at that point, there would be a record. And yeah, I would consider sanctions, and I would think to myself, if I can't even get them, if I'm having to sanction a party under 37F, we're gonna have a lot of problems with discovery in this case.
Thanks. You know, I've got a plead that I created the error on this one. She did indeed type 37F, but I thought 37F had been repealed. So I assumed it was a typo.
37F is still out there, David, but it's so rarely used. I haven't seen it in 10 years. I mean, it's available and out there for someone who's refusing to participate in a conference robustly and in good faith. But as Judge Goddard said, if that motion's being filed, there's a problem with that case, and it probably deserves some really special handling, perhaps discovery status conferences set every month, you know, creative thinking on how to get this resolved. But it would definitely go on what we call the babysitting list, and have to be babysat throughout the course of the litigation, or at least until we knew the parties could get along.
Excellent. Well, thank you everyone for jumping in on this one, and I will stop correcting what I think are typos. Let's go on to our next topic. And this is taking us from the Federal Rules of Civil Procedure to the Federal Rules of Evidence. And this is something that we've talked about ever since it was promulgated in 2008, and that is avoiding waiver on Rule 502D. Let's start with you, Judge Goddard, on this one. Your Rule 26 checklist provides that parties must discuss, and to quote your checklist, whether a separate court order under Federal Rule of Evidence 502D is appropriate. Would you go a step further and say that parties should almost seek a 502D order, and if they have an ESI protocol, should the parties agree to seek that 502D order as part of the ESI protocol?
So, I mean, the answer is yes, but I don't feel comfortable putting in like a guidelines, like you should do this, you should do that, right? But I think it's kind of self-evident. If you're going to take the time to have sussed all that out and to be dotting the I's and crossing the T's in that way, I don't see why you wouldn't. And maybe someone can explain to me, because I'm not thinking it, I don't have that perspective. But and I was just checking to make sure, unless Judge Peck is here under his pure delicto or whatever his secret log on is, I don't see him on here. But I agree with him. I think that you should do it. but I try not to tell people what to do, at least not in writing. I just try and be bossy, verbally. So.
Thanks, Judge. Judge Barksdale, let's bring Middle District Discovery in on this. And it provides only that an agreement among the parties to limit waiver is binding only if it's incorporated into a 502D order. Would you go beyond that and say there should almost always be a 502D order, and that if there is an ESI protocol, should it always be in there?
Well, first, David, I'll say our uniform case management report that has to be filed in nearly every civil case has a checkbox for the parties to look at, and it says the parties have considered privilege and work product issues, including whether to ask the court to include any agreement in an order under Federal Rule of Civil Procedure, or excuse me, Federal Rule of Evidence 502D. And so the parties have an opportunity there to ask for it in our case management and scheduling order, and that's where we'd usually find it. That being said, we rarely get requests for 502D orders, rarely. And so we rarely enter them. David, I feel like we were at a University of Florida e-discovery conference once, and lawyers started chiming in on why they don't ask for those. Do you recall their reasons?
Yeah, I do. And they were concerned that if you entered into one, that it was going to be held against you in future litigation, even though it was, the rule specifically states that it's not in most cases. In addition, we used to call it the Peck poll because we would do that poll year in, year in. Most of the time at the beginning, lawyers hadn't heard of it, and the technologists hadn't heard of it either. And it was only in the last few years anyone had even heard of it. They just didn't know about it.
Well, it has, I think the Rules Committee had such high hopes for 502D. It would save so much time and expense because lawyers wouldn't have to review every single document or every single piece of ESI. And if it had privileged information, the order would just set into place. It's just not had the intended effect. And I'm not quite sure why. I think lawyers are just so afraid to not review everything produced.
Exactly. We've had a question come in, and on this same theme, we have Federal Rule of Evidence 502B as in Bravo. Do we really need Federal Rule of Evidence 502D? And should we go to the extreme measure of making it part of an ESI protocol? Judge Richland, your turn to weigh in on this one. And if you want to address the question, is 502B as in Bravo a good enough thing? And generally, would you think that it should be in an ESI protocol?
Yeah, I don't understand why you wouldn't seek a 502D order in every case. I agree with Judge Barksdale. I haven't seen those get requested, but I know, in practice, in any big case I had, that's just on my standard checklist. And I do think that's an area where you can have a boilerplate 502D order that you really need to pull out. You can tweak it, but that's just in your standard toolkit. I don't see the downside. I don't really understand the hesitation there. So I would always have it in any big case.
Great. Thanks to everyone from jumping in on this one. All right, let's go to another issue that has been a really hot issue as of late, and that is hyperlinks. Are they an attachment? Are they not an attachment? In 2021, Nichols v. Noom really kicked off this discussion. There has been case law since then, and Ray StubHub. Just this year, and Ray Uber Technologies. Why don't we start with Judge Goddard on this one? What do you think on this one? How would you address the issue of hyperlinks? And is it something that ought to be addressed in an ESI protocol?
So the Uber case is a great example of how important it is to talk about these issues up front, because this was going to be a big issue in the case. And the parties had run into like a loggerheads on the ESI protocol, and they went to Judge Cisneros and said, help us out. I'm not quite sure they said that politely, but they indicated they needed court intervention. And it's better to be asking those questions beforehand. And there was a little bit of a tension in that case from with the decision to use Google Vault, knowing it can't do this. But I also think that I would recognize that businesses use different programs, not because when you're making that decision as a business decision, it's not always for the one that preserves the the litigation evidence in the easiest way to retrieve, right? So there's business reasons for choosing one technology or the other. There was some criticism, I think, on the plaintiff side that Uber was using Google Vault, knowing that it didn't have the capability to really easily address hyperlinked attachments. It's difficult, and I think proportionality is going to factor into it in every case. And I think that's what you see in the cases that have addressed it. It's going to be a question of how important are those hyperlinked documents, because I don't think that there really is any easy fix for any of this. I know that I was at a conference last year for a particular vendor, and they were working on a solution. But if you had, for example, Google Drive links in a Microsoft system, there might be a way to there might be a way to manage hyperlinked documents that are on a OneDrive, but it gets tricky when you're going Google versus Microsoft. So I think it's going to depend really on the case, and the level of issue or the level of work it warrants going into it is going to depend on the proportionality and where it fits into the case as a whole. So there really is no easy answer. It seems like from a technological perspective, I would have hoped that we would have come further on this, but I'll lay the blame at the foot of the Googles and the Microsofts, because I don't know that they're designing their systems in a way that's making it easy for their users to extract the data that they need in a litigation situation. So you still got to talk about it.
I'm sorry, Judge Goddard?
Still got to talk about this. Something you got to talk about. This is something you need to be thinking about. Is this going to be a problem, and how are you going to resolve it?
Thanks, Judge. Judge Barksdale, Judge Richland, anyone else want to jump in on this one?
Just that I agree completely with Judge Goddard. I mean, it might not have to be part of a protocol, but it should be discussed. I mean, hyperlinks are enough of an issue today in most cases that just have the discussion as part of your conference. But the issue could take up a whole seminar. In fact, David, I got an email today from Doug Austin's eDiscovery Today advertising a seminar just on eDiscovery and hyperlinked files and emails. And so for anyone who doesn't know what we're talking about, there are seminars dedicated to that topic. And I think it's worthwhile for both lawyers and judges to go to those seminars and understand the issue with hyperlinks.
Thank you, Judge Barksdale. Judge Richland?
Well, I would say, I think the lesson, the broader lesson that I hope folks take away from the hyperlink issues in those cases is that it's really critical to understand how the client is communicating. And that's particularly difficult in a big company. And so, I was the head of litigation general counsel many years for a very large company. We're a national company with 50,000 employees. And part of my job was to understand, and it never ceased to amaze or scare me, the way that the company was communicating, the things that they were doing. And I was finding out that teams were, recording those trainings that I was giving to them and sharing them, and, which they thought they were being helpful, or, just the way people were talking to each other, where they were saving things. They developed all the different platforms they were using, right? I think it's so critical to understand how information is being shared, communicated, and stored, and you don't always realize that. I think this is an area where in-house counsel can play a critical role in. So if you're outside counsel, work with your in-house counterparts, and then, set up calls with the IT team. I used to do this on big cases, is I would set up calls between my IT leadership and our outside counsel, and we would have those discussions. Where is the information going? What systems do you have in place? Because you don't know. I didn't know that this department had this new software application that they were all using. Nobody told me. And so unless you got to ask those questions and go straight to the source and talk to the people. How are you communicating? Are you texting? Are you using software applications? Are you using software applications that are not approved by the company? I mean, that happens. So that's the lesson that I hope folks take away from this, is to dig into what's happening on the ground, what information is out there, and that's how you have to engage in it.
Thanks, Judge. We've got our final topic of the day, and not surprisingly, that is artificial intelligence. And we were speaking of Judge Peck earlier. He sent in a comment, and I'll read this quickly. And he's got, we must be careful not to do to AI for e-discovery what happened to TAR. All studies show TAR is as good, at least as good, if not far superior to keywords and manual review. But many lawyers and clients do not use TAR because of the concern that discovery motion practice and complicated validation measures will take away the cost savings of using TAR. So at the moment, they use TAR for prioritization of review from behind the firewall, so to speak. Perhaps lawyers and clients who don't want to be early adopters of AI will, for e-discovery, be late adopters of TAR, he asks. The AI issue is an interesting one, and as many of our viewers know, from his DeSilva Moore case going on to other cases, Judge Peck has always been a big proponent. As far as AI goes, judges are jumping on the bandwagon. Judge Starr in Texas has the first one that I know of, Judge Bailson in Pennsylvania. And as of the moment, EDRM's repository carries 27 standing orders with AI repositories. Famously, Judge Scott Schlegel, state court judge out of Louisiana, put an article out where he said, you know, the existing rules can basically address these issues. And then he candidly admitted that he had ChatGPT help him with his drafting of it. But he's very learned on these issues. He's a tech-forward judge. Judge Richland, let's stick with you on this one. We've got 27 standing orders across the country. We've got others saying they're really not necessary. How do you come down on the issue?
So I have not yet jumped on the bandwagon. I do not have one. I don't think you need one. I'm on the side of, I think the normal rules are there. And, you know, just as an example, you know, you mentioned ChatGPT, everybody's very hyper about that. I don't think I need a rule to tell people that they either can or can't use ChatGPT or have to tell me if they do. You know, you have to file a brief that you have to have read and you're responsible for it. And if you use ChatGPT and it has a problem in it, I'm going to hold you responsible for it. I don't need to know, you know, I don't need to know how the sausage is made, but I am going to hold you accountable for how it turns out. So.
Thanks, Judge. Judge Goddard, what's your thought on it?
So I agree with Judge Richland and Judge Schlegel, mostly because Judge Schlegel can make a mean deep fake of me if I cross him in any way. So I know he's got a lot of skills when it comes to Gen AI. But beyond the fact that I don't think they're necessary, I think there's a few other things to think about with them. A lot of them are overbroad in how they define AI and Gen AI. We use Gen AI, and first of all, like if you just looked at like what things are called, I don't even think BARD is called. I think BARD is now Gemini, and the terminology is changing. ChatGPT versions are updating, but also like we use Gen AI all the time. If you use Microsoft Word, you're using Gen AI if it's giving you if it's kind of auto prompting what the next word is. And Grammarly, you know, we use versions of AI and spam filters. Like so I think that a lot of the standing orders are overbroad in how they're defining it. And I think they can deter attorneys from testing or using Gen AI altogether. And I don't want them to do that. We should be looking at Gen AI as a tool that we learn how to use responsibly, but not something we're afraid of. And then I think the reality is they're likely ineffective because the people who are going to misuse AI tools are not going to be reading your standing orders. And I think I've mentioned this to you before, David. I've said that we shouldn't be so worried about hallucinations because lawyers do that all the time anyway, even without Gen AI. They tell us the case stands for a proposition that it doesn't stand for, or maybe isn't as good a law anymore as they say it would be. And we have to be alert to that anyway. So the fake cases are easy to find. It's harder to parse through and see where an argument's being made that doesn't really jive with the law. But I am definitely not a proponent of the standing orders. Some of them can be really problematic. Some of them require lawyers to actually save and preserve any prompts they use in Gen AI that might be involved with the brief. And I think that's just really highly problematic. And I think it just misunderstands the technology. So I'd rather be embracing the technology in a reasonable and cautious way by getting people to experiment with it and leaving and being open to that.
Thanks, Judge. Judge Barksdale, I'd like to get your view on this one, and maybe there's a way we can split the difference. We both have had the honor of working with retired Florida State Court Judge Ralph Arteglair over the years. And Judge Arteglair is very supportive of the Florida Bar Board of Governors proposed advisory opinion, not a standing order, but it's an advisory opinion addressing the use of AI by lawyers. And he noted that it was based on ethical commitments of professionals and it's to be guidance rather than a hard and fast rule. Do you think advisory opinions may be the way to go and maybe a better option than standing orders?
Well, no, I mean, I think the existing rules cover our bases. I really do. So I don't think even advisory opinions are necessary unless they can provide guidance beyond what's already out there with Florida bar rules. There's already a lot out there. And I think it's what's out there is general enough to cover specific instances of AI misuse. So I don't like standing orders generally. I don't like them, especially on this topic. So I know you like disagreement among judges on your panels, David, so that it can make the presentation more feisty, but I wholeheartedly agree with Judge Goddard and Judge Richland. And I don't think an advisory opinion from a bar is necessary either.
Thanks, Judge. And, sometimes the unanimous decisions are the best. We see the contention in the media all the time, and they talk about contention at the Supreme Court. And what never makes the headlines is there are a huge number of U.S. Supreme Court decisions that are, in fact, unanimous. And it just doesn't get a whole lot of play. And I think we all appreciate how cordial and professional the judges we have on these programs are. So thanks. With that, I know we want to turn back to Kat at the very end, but it'd be great to get a final takeaway. And why don't we start with you, Judge Goddard?
Sure. So, and I'll use this opportunity to answer, I think, two of the questions that were in a sideways way that are open. One is a question about whether parties could use Purview, Microsoft Purview. As a rule, just like everything else, it depends on the case. So Purview can be good and Purview can be problematic depending on the type of the case. So everything that we talk about now should be, the takeaway for me is everything is on a case-by-case basis. But there's general principles that apply, which you should pick up on. And Kelly Twigger asked about what do you do when a judge isn't as well versed and you can't get them to get involved, right? And you have to just to remind the judge. A lot of judges, look, when I saw 37F, I'm not gonna lie, I have this right next to me. I looked it up. I'm like, what's 37F? Oh, wow, I can do that. Wow, that's a whole nother thing I've got, right? So maybe the judge doesn't know about 37F. Maybe you need to point it out. Make sure if you've got a judge who's not as engaged, reach out to them, be prepared for your scheduling conference and be ready to tell the judge you're gonna need help here. And most judges, I think, I can't deal with the outliers, but I think most judges, even if they're not as familiar with this in this area, are very customer, especially magistrate judges we're very customer service oriented. So, but we don't know you need help with something unless you ask for it. So that's what I'll leave you with. So appreciate this opportunity.
Thank you, Judge. Judge Richland.
So briefly, I'll just to also address the issue of education and sort of I'll broaden it out of sort of how do we address folks in the bar or on the bench who may not be as up on some of these issues. One of what I would urge folks on this webinar to think about, because there's a lot of you who are involved in putting on some of the great seminars, the in-person seminars. And what I've been saying to those organizers as I've been attending is, there's a lot of talking about the legal implications of these very technical issues. There isn't enough demonstration and interaction. I would love it if at some of these seminars, we actually had a mock session where we broke up into small groups and we negotiated search terms and exchanged search term hit reports, and people could actually see, okay, I see now. I'm going to change the connectors and I'm going to run a new search term hit report. And I'm going to look at, I think there's some interaction and demonstration of some of these issues, show people, let people see and get into relativity for a minute. And then when we're talking about production specifications, it would make more sense. So I'd love to see a little bit more tangible show and tell interaction components at some of these seminars where it's not just talking high level, but it's education for everybody.
Thanks, Judge. And the final word with Judge Patricia Barksdale.
I get the final word.
You get the final word.
I love that idea, Judge Richland, just demonstrations. That's how people learn the best. But I love that question. What do you do with a judge who's not engaged or not interested in hearing about e-discovery disputes? It's just a really hard question. I mean, as magistrate judges, we see a gazillion types of issues a day. We're experts on nothing except maybe federal rules of civil procedure, but even then we might not know what Rule 37F says. And it's just a product of our job. We're such generalists. We see everything under the sun in criminal and civil law. So the answer to that might just be really aiming to make things simple, but not too simple. You don't want to insult the judge. The judge might actually know more than you about e-discovery. So trying to determine the judge's knowledge base and knowledge level, and then making it easy to understand what the issue is.
Thank you, Judge Barksdale. One final legal tidbit. Rule 37F was, in fact, repealed by Public Law 96-481 in 1980, but it was brought back. Rule of thumb, always have a current version. Cornell is great at giving you some of the rules as they currently stand. So I like to think we all learn something in these things. On behalf of Judge Allison Goddard, Judge A. Joel Richland, and Judge Patricia Barksdale, thank you for joining us, and let's turn it back to Kat.
Well, thank you. I also want to thank Judge Richland and Barksdale for teeing up our workshop, which is the final session in our series. It will be led, once again, it'll be led by Kelly Twigger, which is always exciting. And so I would encourage everyone that is participating today to join us for the workshop on July 18th. And beyond that, thank you all so very much for making this just a terrific panel, very insightful and thoughtful questions. David, always a great job. So I don't have anything else but to say thank you, and I hope to see so many of you at the next session.
Thank you.
Thank you.
Thank you.
Thank you.